Welcome to today's Talks at Pulitzer, featuring New York Times journalist Carol Rosenberg and David Cole, National Legal Director of the ACLU. I'm John Sawyer. I'm the Executive Director at the Pulitzer Center. This session is part of our online summer Talks at Pulitzer series with a focus on justice. COVID-19 forced the postponement of our 2020 Justice Conference, but we believe it is critical, especially these days, to keep issues of justice at the forefront of our reporting and our conversations. We knew that already. It is even more apparent on a day like today, when George Floyd's funeral is taking place in Houston, and when Black Lives Matter demonstrations across every state of the country, demanding an end to racist police policies and the grossly discriminatory government policies and social practices that have been a part of this country since its creation. The Pulitzer Center is committed to addressing those injustices in our journalism and educational work and in our public engagement more generally. While we're waiting for more folks to join us, let us know in the chat where you're listening in from, what cities and countries you're calling in from. If you've joined us for earlier talks at Pulitzer, you know that the Pulitzer Center is a nonprofit organization that funds nearly 200 reporting projects a year across the globe, that we work with hundreds of universities and K-12 schools to engage the public in the systemic issues our journalists cover, and that we stage public events like today's session that reach thousands of students and teachers each year. For any teachers listening, or parents of school-age children attempting distance learning, please check out our educational resources and printable lesson plans and news articles from our very busy K-12 team. Of course, you can find all the reporting and educational resources on our website at pulitzercenter.org. Now, a few housekeeping matters before we move on. We'll have the conversation between David Cole and Carol Rosenberg, and then we'll have time for some questions from all of you. You'll see a Q&A icon on your screen, and you can begin adding your questions there throughout our initial conversation. So please go ahead and do that. There's also a chat icon on your screen, and we'd appreciate it if you'd use the chat box for more specific technology issues. Note that all attendees here are muted, but if you cannot hear us, let us know via that chat box so we can fix it if we can. Remember that any specific questions should go into the Q&A for us. We want to let you know we're recording the session today and post it online for others who could not join us today. We're hoping later on this year to turn this into curricular materials, highlights from this series that we can use in our schools and universities. And one final housekeeping matter, please remember to stay online once this session ends to participate in a brief survey to help us better serve your interest. Now, I'd like to introduce Carol and David. Carol Rosenberg has been reporting on the U.S. base and prison at Guantanamo Bay, Cuba since 2002 for the Miami Herald. In 2019, thanks to a unique collaboration between the New York Times and the Pulitzer Center, she joined the Times to continue reporting from and on Guantanamo. She joined the Miami Herald staff in 1990 as a Middle East correspondent. Her Guantanamo coverage has received the Robert F. Kennedy Journalism Award and the ABA Silver Gavel, among other honors. She was also part of a Herald team that won the Pulitzer Prize for breaking news coverage in 2001. In his role as the American Civil Liberties Union's National Legal Director, David Cole directs a program that includes approximately 1,400 state and federal lawyers on a broad range of civil liberties issues. 1,400 state and federal lawsuits on a broad range. He manages 100 ACLU staff attorneys in New York headquarters, overseeing the organization's U.S. Supreme Court docket, and provides leadership to more than 200 staff attorneys who work in ACLU affiliate offices in all 50 states, Puerto Rico, and Washington. The ACLU has for years been involved in Guantanamo cases. And with that, I'll turn it over to David to lead this conversation.
Thanks, John, and thanks, Carol, for joining in this discussion. We're seeing you're seeing on your screen some images from Guantanamo. You know, Carol Rosenberg has sort of been the person who has consistently brought us news about what is happening there. The government chose Guantanamo as a kind of no man's land to hold people in the immediate aftermath of the attacks of September 11th. And in part because it would be away from public scrutiny, away from the eyes of the world. But they failed in that respect, you know, through the work of Carol and many other journalists and civil society organizations in the United States and around the world. A tremendous amount of attention was brought to Guantanamo. It became, in many ways, the symbol for the George W. Bush war on terror. It became a kind of an albatross around the neck of the Bush administration in its dealing with Europe, because so many European countries were very critical of what we were doing there and were, frankly, having difficulty cooperating with the United States on other matters because the Guantanamo situation of indefinite detention without charges, without trial, was seen as so anathema to the basic principles of the rule of law. But you know, that was then, and now is now, and in many respects, you know, Guantanamo is a shadow of its former self, as we will talk about. There are far fewer people there. There are far fewer reporters there. There are fewer human rights organizations there. There is less attention from the world on this eyesore, essentially, in terms of America's reputation. And yet, Carol Rosenberg has stuck it out and has not let us forget about what is going on there. So we want to talk today about sort of, you know, how we got here, what the current situation is, and the challenges that we face, that both journalists and lawyers and detainees and the American military face in continuing this practice. So, Carol, maybe you could start by just sort of telling us, sort of reminding us, sort of, you know, how many people have been there, you know, over time. How many people are there now? How did they how did the ones who did get released?
Okay, Guantanamo, the prison, opened on January 11th, 2002 with the first 20 detainees. And you see that opening day on your screen as it happens. Mm. And across the years, 780 or so prisoners have been held there. And one of the reasons we don't know exactly the number is one of Guantanamo's continuing secrets is there was a black site there between 2003 and 2004. And we have never been able to surface exactly who and how many were held there.
So can you explain to people what a black site is?
Certainly. Black site was after the 9/11, the CIA set up a secret prison network overseas in Europe, in Asia, and in Afghanistan, and in the Arab world, that kept prisoners out of reach of the International Red Cross. They got no ICRC visits, out of reach of the legal system, out of reach of lawyers, and out of reach of the courts. And the CIA used these sites from 2002 on from 2002 until Barack Obama closed them down to interrogate and hide from the world the so-called high-value prisoners. And why that's of interest, I think, is that while Guantanamo was the public face of detention policy, and people talked about how they had suggested the worst of the worst were in the Guantanamo prisons, and actually there was a parallel prison system going on, run by the CIA under the Bush administration, that kept over 100 prisoners out of reach of all of those.
And one of them was on the island of Guantanamo, but just not acknowledged to the world.
Correct. In 2003 and 2004, there was a black site at Guantanamo, and famously, the agency ran those people off the not far from where this actual picture that you're seeing is. The agency rushed those people off the island into other black sites when it became clear that the United States Supreme Court was going to give prisoners at Guantanamo access to lawyers. They were looking at a case, and the calculation was, so important to know that for the first 963 days existence of the Guantanamo prison, there were no lawyers. The lawyers were not allowed to go see their prisoners. It was deemed to be out of reach of the courts. So anyways, across those years, there were 780 or so. The Pentagon has acknowledged 779 prisoners. They call them detainees because they say they are in a temporary detention status until the war is over. It's a Bush and then Obama administration improvisation on the concept of POWs for this endless war. And we're down to 40 now. I think we're getting ahead, but 790 or so. The first 540 were released by George W. Bush. People don't remember that, but the Bush administration thinned that camp down to those camps down to about 240 prisoners by sending hundreds away. Hundreds of the prisoners came from Saudi Arabia, Pakistan, and Afghanistan combined. And nearly all of them were sent back. Certainly, nearly all of the Saudis and Pakistanis were sent back during the Bush administration. And then the Obama administration comes in seeking to close in. I'm sure you'll ask about that, and continues to thin the detainee population through transfers to today's 40. You want to know about today's 40?
Yeah. So it's interesting that the Bush administration actually released far more prisoners from Guantanamo than the Obama administration did. Of course, the Bush administration also brought them all to Guantanamo in the first place. But Obama came into office promising, as I recall, to close the prison, but was never able to do that. So why not? What was the obstacle to basically, putting it behind us under a president who ostensibly wanted to do that?
The Obama administration would say that Congress prevented them from doing it, but that's sort of the micro explanation. But the macro explanation is that, in fact, the Obama administration over time came to believe that closing Guantanamo meant moving Guantanamo, picking up those prisoners and taking them to a military detention in the United States, and continuing that quasi-POW status for some in some sort of a military-run U.S. setting for those that would not be charged and tried in federal court. And Congress rose up and would not fund that concept and systematically prevented people from being transferred to the states. It became a very politicized domestic politics talking point that it would be, that America might see former Guantanamo prisoners released onto the streets of America, and that scared people. In fact, there would have been probably a system that would have deported them if they were somehow ordered released by the courts, which has happened at Guantanamo. Rarely, very rarely, but if there was a release, they were not going to be released onto the streets. But it's a comfortable political issue for people to demonize and talk about how dangerous it would be to pick up these 40 men and move them to detention in the states. And I have said that I think Guantanamo is Congress's favorite prison. They like to go there on trips to inspect it, they fund it, they support it, and it's a comfortable place for politicians to support.
So, and it's also an expensive place for politicians to support, right? The latest figures I've seen are that it costs $540 million a year to keep Guantanamo open for 40 prisoners. That means they come at a cost of $13 million a year. The cost of imprisoning someone in the United States is said to be, anywhere between $20,000 and $45,000 a year, depending. Here we're paying $13 million a year. Of the 40 people who are left there, let's get a sort of picture of who they are. My understanding is some of them are actually awaiting trial on charges, but there's a big chunk of them who are still held without charges, right?
That's correct. Under the construct of military detention at Guantanamo, you don't have to be a war criminal or accused of being a war criminal or charged with terrorism crimes. The concept is that this is a irregular POW camp holding people who are, as they like to say, removed from the battlefield, which was a rarity. Most of these people were picked up by Allied security forces and handed over to our agencies. But these people are considered enemy combatants, a form of POW, which means that under laws that have been held up, they can be held for the duration of the conflict. One man there has been convicted of a crime and is serving life. He was a filmmaker, propagandist, media aide to Osama bin Laden, and made an Al-Qaeda recruiting film that was shown at his trial many years ago. He did not participate in his trial. He boycotted, essentially, said that the US didn't have the authority to try him, and the military jury sentenced him to life. He is the only prisoner in the military's view at Guantanamo, and everyone else is detainees, suggesting that unless they are convicted of a crime, if the war ends, they could leave.
And you say removed from the battlefield, and they're held for the duration of the conflict. What battlefield and what conflict?
So the battlefield, based on the Guantanamo theory, can be the globe. It can be anyone who was an affiliate or a member of Al-Qaeda or an associated militia. And, there's 5 men on trial for having plotted the 9/11 attacks, and all of them were picked up in Pakistan in Pakistani security raids. And I think probably never met a U.S. soldier, a member of the U.S. military, until they arrived in Guantanamo in 2006. They were held by the CIA. They were intelligence prisoners. The CIA may have been wearing military uniforms, but the concept that they met on a battlefield is not exactly correct.
And the conflict? The conflict?
Is the global war on terror. It is that's a very valid question, especially for a lawyer to ask, because the conflict is defined by something called the Authorization for Use of Military Force, which defines it as the war with Al-Qaeda and the Taliban. And it has continued to expand into used for droning and other, as an authority for droning ISIS and ISIS affiliates. But there is still an open question about whether that AUMF would apply for the purposes of Guantanamo detention to people who aren't affiliated or members of Al-Qaeda, Taliban, or affiliated forces. You can define the conflict better than I can, David, I'm sure.
So I think that is one of the real questions here. It's a sort of open-ended authorization to use military force. You might say that we have defeated Al-Qaeda and the Taliban, that there's no longer an operative battlefield, but that's obviously not the position the United States has taken. But what about if
a lawyer were to prevail, I think in that position, Guantanamo would not continue to exist without another act of Congress.
Yeah. So these people have been there now for coming on close to 20 years, in a state of kind of suspended animation. They have there's no end point in sight. Only one of them actually is serving a sentence. You know, what does that do to the folks to be in that kind of situation, that kind of limbo for that long? Have you had a chance to interview them? Have you had a chance to observe their demeanor at hearings? What's your sense of you know, how are they doing?
So no, I have not been allowed to interview them. Pentagon policy is if you speak to a prisoner, you can be banned for life from ever going back to Guantanamo. They forbid reporters to talk to the prisoners, the detainees. Even some years ago, and their justification for it is the Geneva Conventions protect people from what they call parade and unwanted attention. But years ago, I did get a series of waivers from some of the prisoners saying they would waive their Geneva Conventions in order to do an interview, but that didn't work out. There really, in terms of the prisoners, there's two sets of prisoners. There's those prisoners who came from the CIA black sites in 2006, the high-value detainees, and those are the men who are currently charged with crimes. They're from that category, and those men were captured between 2002 and maybe 2008. And then there's what they like to call the general population prisoners, the low-value detainees, the ones that when they used to let the media come, we'd see in their detention settings from a distance or through one-way glass. And those people include people who arrived that first day, January 11th, 2002. And I think that the detainees who came from the black sites are, at this moment, there's really no exit for them. They go through, the ones who are facing trials are awaiting trials, and the ones who have been uncharged go through these periodic review boards that systematically uphold their detention as lawful and that declare them too dangerous to be released. The whole concept of Guantanamo is they will let you go if they think that there's a way to prevent you from being dangerous when you go out there. And the interagency board evaluates your proposal for where you would go and your vision for life after Guantanamo, and decides if you're a safe prospect for release under conditions. And none of those former CIA prisoners have ever even gotten a glimmer of close to meeting that threshold. But the low-value detainees, the general population prisoners, with the exception of the filmmaker, have not been charged with crimes, and 5 of them have been cleared through those panels and not released. And the rest of them go through the panels, but see the other 5 who have been cleared but not been released. And I speak to their lawyers, and they describe, and certainly in the low-value prison, a real atmosphere of, you know, resignation, depression, concern over what's happening to their families back in particularly this moment of coronavirus. But prior to that, many of them were Yemenis worrying about their families in the Civil War, and they feel that they're forgotten, that, you know, the focus has moved on to the trials. The prison, the detention center, hasn't allowed reporters in there for more than a year. Guantanamo is a hard place to cover. I don't think that they necessarily are heartened by coverage, but they don't want to be forgotten. You know, back in the Obama administration, they felt they were forgotten when there were hundreds of them, and they went into and they staged this incredibly large hunger strike and did get attention. Now the numbers are fewer, and the prospects for release are very grim.
Now, when you said five have been cleared for release but haven't been released, what's holding them back?
Well, each one has a little bit of a different story, but the bottom line is that 2 or 3 of them were held back because the Obama administration changed to the Trump administration, and while there had been arrangements made to repatriate someone to 2 of them, Morocco and Algiers, their native countries, it ended when the administration ended. They closed the office at the State Department that negotiated those transfers, and Trump administration has done nothing to clear them. At least 2 of the other prisoners were cleared as far back as the Bush administration. Bush administration, using a different standard, said they had no intelligence value to offer the military and could be sent home safely if it was arranged. There's also a man who's a Rohingyan, and the question is, where do you send him and who would take him? Mm-hmm. Some of these people it's a debate about whether they're damaged and how they're damaged, but one of the criteria for being able to leave if you're cleared is you have to come out, sit across a table with a diplomat from a foreign country and make an argument for why that country should take you back or take you in, and want to go with the program and move on with your life. And at least 1 or 2 of these men are just really incapable of doing this. Radicalized, damaged, mental health damaged as a result of the detention. It's very hard to know exactly, but for those men, but anyways, the bottom line is there are 5 are cleared, and they really have no prospect of leaving under this formula because there's no one negotiating the release. And one of the criteria for being eligible for that is that you will not be charged with a crime. There is no war crime out there that you would be accused of, not and be able to try for. So they're just stuck there. And I think that those 5 low-value detainees, some who arrived in the first month of Guantanamo, really speak to, sounds terrible, but the depression of the rest. They know that there's no exit from Guantanamo right now. And a lot of these guys are foot soldiers, low-value detainees, people that if they could, there's one fellow there who's an Algerian, and his family bought him a pizza parlor, and he had plans to go home to Algiers and run a pizza parlor and have the next part of his life. And something diplomatically went wrong with the ability to let him go, and his defense lawyers were heartbroken and continue to be that they couldn't get him out before the change of administration. But those are the 5.
Yeah.
The others include, so over on the low value side, none of them are really eligible for trial. As I said, trial means that you have to meet the threshold for being accused of having committed a war crime. And I mean, I think we should just explain it for the benefit of the people who might not know. War is, I meet you on battlefield, David, and I shoot you, typically. A war crime is you're lying on the ground and I kill you. It gets more complicated when I'm an authorized force and you aren't, and so there's other grays that can be entered into it in the military commissions and in Guantanamo. But being a foot soldier is not a war crime.
Right.
And then the people who are up for trial are the high-value detainees from the other prison who were held in isolation, incommunicado. As I said, no lawyers, no access to the Red Cross for 3 and 4 years.
So let's talk about them, right? Because
sure.
So we
and
have,
they're the most famous detainees at Guantanamo.
Right, we have charges. Some of them are charged with the crime of 9/11. Of hijacking the planes and killing 3,000 people in the World Trade Center, and Pentagon, etc. And here we are, 18 years later, and we still haven't brought them to trial. Right? It's remarkable, and probably the most infamous crime in our lifetime. Not a lot of a lot of information about what went on, and yet here we are. We haven't even begun the trial, right? So what are the obstacles to bringing? And let me just say, for disclosure's sake, that the ACLU is part of the team defending the Khalid Sheikh Mohammed, who is accused of masterminding the 9/11 attack. So I'm not a neutral, if anyone thought I was, I'm not a neutral interlocutor here, but I do, want to sort of just have you explain to people, why has it taken so long?
Well, first I would commend people to quite extensive article I wrote during the closure that gives you 10 of the key reasons. One of the things about the COVID-19 closure is we haven't been able to go to Guantanamo. And so there's been time to be reflective. And it really goes through the history and problems of this case and of the military commissions. And it starts with, some would call it, not me, the original sin of taking them to the black sites. And a lot of what is complicating the trial at this moment is the 3 and 4 years that the men were diverted into CIA prisons, unprecedented, as we know, in American society, denied access, interrogated with the goal of trying to find plots and sleeper cells and the next 9/11, and interrogated in sites that did carry out torture and in sites that kept them isolated, incommunicado, deprived them of the most basic fundamental rights that a person tried in an American court of law is entitled to. And it went on for years. And so much of what is wrong, goes wrong or elongates the 9/11 trial starts there. You know, the trial's been going on for 8 years in a way. They arraigned them this time around with this format for military commissions, May 5th, 2012. And they've been doing pretrial hearings ever since. They've been dealing with who would be a witness at this trial. What is applicable evidence at this trial? What kind of access to evidence the defense lawyers can get. The defense lawyers have to be Americans. They have to obtain top secret security clearances. They have to go through a series of commitments and obligations that they do not disclose the things that are classified that they learn in the court and they learn from their clients. And yet there is a different standard by which they can get evidence than the prosecution can. And so that has absorbed tremendous amount of time.
And that's mostly to keep secret the details of what happened in the black sites?
We increasingly know what happened in the black sites in a narrative that has been approved and presented in the through the judges, at some of which I shouldn't say we know. We know a lot of what happened in the black sites through the Senate study on the black sites that came up some years ago. Yep. And there is some narrative that keeps emerging through the pretrial. The judges are given original evidence and allowed to introduce what they call substitutions through something that borrows from the federal court, but isn't exactly the same to SIPA. But what they really are protecting at this point, and what the CIA has drawn the line on, is access and the names of the people who did it, with some exceptions. If they
why would they need that for the defense?
And the countries where they did it. And the countries where they did it. The defense, you know, this is a capital case. The goal is the prosecution in the case is to execute these 5 men not for having conspired in the attacks. None of them, you know, were hijackers. The hijackers are all dead. The defense is trying to create an argument that, a series of arguments for which they want this level of detail, starting with the United States doesn't even have the moral authority to try them because they, you know, tortured them, and want the case dismissed, right up into sort of the goal of, if they are convicted, the United States doesn't have the moral authority to execute them because they were tortured. And so for that argument that will run throughout the entire trial and start before a jury is impaneled, with the military judge being asked to dismiss the charge for outrageous government conduct, which hasn't been filed, but we anticipate, the defense lawyers want the most graphic, personal eyewitness testimony from the people who participated in it, because they will be, among other things, more credible than a prisoner who's accused of this horrific crime giving his version.
Right.
And then, of course, the defense lawyers are loath to put them on the stand anyways, because then they'll be subject to cross-examination, which you as the lawyer can explain all of, you know, dangers of. So if we're talking about the 9/11 trial, basically, they haven't even decided which aspects entirely of the Constitution apply at Guantanamo. There's been litigation and court arguments about this that have established certain things, like obviously the right to file habeas corpus, because that was won 2 years into the enterprise of Guantanamo. But speedy trial, no. They designed this court that doesn't have speedy trial. You know,
Obviously not speedy trial.
Correct. And so we have legal arguments being sorted out. We have discovery issues about what evidence they can have. We have the problem that it's at Guantanamo, which right now, the court hasn't been in session in any case for over 100 days because of the COVID. The soonest the court could go back into session under the calendar is 150 days after the last hearing, 160 days after the last 9/11 hearing. COVID has closed down Guantanamo. The fact of Guantanamo, and the only people to go, that court opens, it starts with an airplane in Washington, D.C., and everybody except those who were accused climbing onto that airplane and flying down, and somebody turning on the light switch at the Military Commission's courtroom at a old airstrip called Camp Justice. These trips are fraught with problems. There's logistical problems, there are technical problems, there have been health issues, and while there have been more than 36 rounds of hearings, some lasting as little as a day because some sort of obstacle emerged, and others lasting, I think, 3 weeks maximum, maybe 4. They are all fraught with, it's not like getting up in the morning for a reporter or for a defense lawyer or for anyone and walking to the courtroom steps and going in and hearing the case. It's a military-run, military-managed court. The judge is military. The bailiff is in the military. We can talk about it at length. We could do a whole thing on the 9/11 trial, but the public hears it on a 40-second delay because the intelligence agencies are able to exercise a prerogative that something is classified. The public shouldn't hear it. It would be considered a spill.
Yeah, so it seems like
I could spend the entire session talking about why the 9/11 trial hasn't happened, but
yeah, it seems like sorry about that. It seems like there's sort of three basic challenges, right? The first is the torture, because it can, it can affect the evidence which is brought in. It could be relevant to sentencing, as you suggest, et cetera. And that's not something the government wants to have tried in a public space, but when they want to try the defendants, it's a legitimate part of the case. So that's one problem. Another is the secrecy, which makes it, as you suggest, very complicated. And then the third is that they chose, and it was a choice, right, to do it, sort of start from scratch, to not use the criminal system that we have here, which we have prosecuted and convicted many terrorists under, but to sort of start a system from scratch. And anytime you start a system from scratch, it's going to be a major challenge to make it work and to take sort of one of the most significant crimes in our lifetimes and to say, let's not use the established system, let's just start from scratch, where you've got these problems of secrecy and torture, which are tremendously difficult problems. It's taken a very long time.
The chief prosecutor, Mark Martins, would argue that they didn't start from scratch and that military tribunals and military commissions are a long history of being used through American conflicts in different ways. And furthermore, this court is a hybrid. They took some things from federal practice. They took some things from court-martial cases, the Uniform Code of Military Justice, and they created this thing called the Military Commission, which actually, in some ways, is harder because the military judges, they know the manual for court-martial, and now they have this thing that's layered on it, this version of CIPA, the Classified Information Protective Act, and they have to sort this out, and they have extraordinary powers, and most of these judges have never been involved in a capital case. The military doesn't do very many of these, so there's lots of problems there. But to the idea that it was started from scratch, there are advocates for the system who just say this is not completely unheard of, and the military knows how to do this.
No, not unheard of.
Which takes you to the original problem, which is the 3 to 4 year detour on their way to Guantanamo and justice.
Yeah.
John, hi.
So I think, so John's appearance suggests that we are going to go to questions from the audience. Let me, while we're doing that, let me just ask one last question, which is, there was a tremendous amount of litigation and attention on Guantanamo and the Supreme Court, which ultimately led to 2 Supreme Court decisions, Razul and Boumediene, which basically held that the prisoners at Guantanamo have a right to come to court in the United States and challenge the legality of their detention.
And Hamdan touched upon that as well.
Yeah, huge decisions, right? Which essentially extended the writ of habeas corpus to the people at Guantanamo, gave them access to a lawyer, gave them access to a court in DC. What good has it done?
Well, I think at this moment in time, one could argue that perhaps, and I don't know the numbers, so I'm really ballparking it. We know of 18 people in a group that were ordered released through habeas corpus, Uyghurs, Muslim men born in China, who were picked up in Afghanistan. But at this moment, what habeas does, I believe, is it gives the detainees and their lawyers an avenue to address conditions arguments. Which, you know, habeas before 9/11 was kind of a very narrowly used, I believe, I've been told, in capital cases to try to stop an execution. But in this instance, people have federal judges in DC and in the US District Court on Constitution Avenue who they can go to argue inhumane conditions and seek release. The recent case that's of consequence is the lawyer for a former CIA prisoner has not been able to speak to his client by telephone since the COVID, and a judge is going to has ordered the military to find a way for them to speak by phone, and has sort of raised the stakes and said, if you can't get this guy a phone call, we're going to have briefing on whether I have the authority to order that man brought to the United States so he can meet with his lawyer, essentially. We know that based on past precedent, that won't work, but it would be a real heavy lift for the Justice Department in this moment to argue all these years later why Guantanamo can arrange for a phone call between a former CIA prisoner and his lawyer.
All right. John.
But habeas is now really about conditions of confinement, a resource for hunger strikes, to complain about things, and to seek intervention by the judges so that the military isn't down there alone making the decisions on its own without people looking over their shoulders, which is particularly consequential at this moment when lawyers aren't there, journalists aren't there, and they are down there on their own doing whatever left to their own devices to manage the base, the prison, the COVID, and the health conditions.
Right. I mean, one way of saying it is, you know, look at how bad it is. Imagine how bad it would have been had the courts said no right of habeas corpus, no right of access to lawyers.
We wouldn't know who those men were. No. The only reason we know who those men are and their life stories and how they found their ways to Guantanamo, right or wrong, is that they were given attorneys who went down there, sat across a table from them, and asked them to tell them. And then they could tell the courts. Until the habeas happened, they were anonymous, essentially John Does held as prisoner numbers for, again, the first 963 days, not one of them saw a lawyer. Okay, I'll stop.
So, Carol and David, thank you both. This is really fascinating. There's so many different strands to this. We've got I think, over 150 people on this call, and they're from everywhere from Cairo, Egypt, to West Palm Beach, to Olympia, Washington, New York City, Canada, Hudson Valley, Liverpool, Lyon, France, Boston, Asheville. So it's we're getting a lot of different perspectives here and some excellent questions. And I want to turn to those, and we'll try to get through several of these in the time we have left. There's one question that I think we haven't addressed yet, that in light of the decline in worldwide attention, I know this is something that Carol has written about, but in the decline in worldwide attention toward Guantanamo, have you observed a similar decline in attention from the victims' families? This is one of the things that we tend to lose sight of here, is that in the discussions about justice, that there are, you know, the victims of these crimes, and what this long delay has meant for them.
There are some very engaged victims who want to see these trials staged occur so they can get answers to questions. And those are the ones who the Pentagon prosecutor typically brings down as their guests to observe the proceedings, groups of 5 or 10, depending on how you count it. There are vocal people who want this trial to be held in federal court because they're just not comfortable with the remote system. There are vocal people who don't even have any faith in any trial because, quite honestly, they believe there's a larger story that no charge sheet can answer about how Guantanamo happened. But yes, I think the victims generally feel forgotten. It's been a long time. The court is far away. The case is incremental. It inches along. 2,976 people died that day. And think of all their families. Think of how many kids and parents and spouses and siblings. So they're everywhere. They're out there. There's a wide variety of what they want. But sure, you know, I don't know what, I remember what 9/11 anniversaries were like in the early years, and in Guantanamo in the early years. 9/11 was a church service and a meaningful moment for the military. And, you know, with all respect, it's now a 9.11 kilometer run to remember a long ago, far away thing from Guantanamo Bay, in which guards who were, you know, babies or toddlers or youngsters are now guarding the detainees, see it like, not quite, but something akin to Pearl Harbor, something to be remembered, something to be respected, a sacrifice. But I think the victims feel, I mean, I know the victims feel forgotten. They tell me all the time. And if you want to talk about victims who truly feel forgotten, the families and survivors of the USS Cole attack, there's a man down there who's awaiting a capital trial on that. That was in October 2000, 17 sailors died. The fathers, I mean, you're getting me started. The fathers of some of those sailors have passed away waiting for this trial to happen. So yes, the victims feel forgotten and are incredibly frustrated with this process for any number of reasons, ranging from people are animated about the torture to people are animated about why, with all respect, they weren't executed long ago.
There's a question from Joyce Lavaca that speaks to kind of just practicalities of covering Guantanamo and asking if the hearings do take place in July, if they resume, how will the military commission logistically handle the quarantine of media and NGOs who will be there? Where will you stay? What will you eat? Can other observers go? I mean, tell us a little bit about, I mean, you've got a lot of experience in staying in those cots and rooms.
I'll try to do this briefly. The chief judge of the military commissions announced that the July hearings won't happen. He canceled them yesterday. The next possibility is in August. The prison and the base at this moment have what they call a restriction of movement for 14 days quarantine that would confine, which would require you to come down 15 days ahead of a court hearing and be, I believe, in my instance, confined to my tent, which is a 6-person tent with plywood dividers for the 6 different beds. And with somebody stopping by and making sure I'm there and haven't violated my quarantine and dropping off styrofoam containers with meals is my understanding the way it would work. Regular temperature checks. The defense attorneys would be put in a barracks, which has raised, I mean, defense attorneys are very alarmed by the idea that they'll be held in a former barracks using communal bathrooms and showers as their designated restriction of movement spot because they question whether this is safe in the time of coronavirus. There are so many answers about how, there are so many questions about how they can hold a hearing that I am not convinced the August hearing can happen either. The Guantanamo has been extremely secretive about testing, numbers of cases. They were under a policy, confirmed a case, one case of a sailor on the base, and then the policy changed where they didn't have to answer the question, and they haven't. The detention center had said one member of their staff was positive, but did not come in contact with detainees. May be the same person, so they may have only acknowledged one case, but they have planes coming and going, and there are people under restrictions of movement there all the time. And they have said they are not, I mean, not everybody who wants a test can get a test at Guantanamo. The military medical care people decide who gets tested. And the people I speak to who continue to talk to me despite the sort of crackdown on media say they haven't been tested and offered tests, but they also haven't been sick. The biggest problem, and I could spend the whole conference on this, but the biggest problem is that Guantanamo doesn't seem to have the ability to explain how they're dealing with asymptomatic COVID. These are young, healthy troops down there. You have 6,000 people live down there. Some are elderly and some aren't fit, but a lot of them are extremely fit and could be carriers and passing it around, and they just won't talk about it. But the answer is that the concept would be that they would take an airplane of people down there 15 days early, confine them to individual spaces, different spaces for different classes of people. I personally have a real question about whether they should be bringing the victims down, because a lot of them are elderly and infirm, and confining them to their rooms for 15 days. But that's the policy. And anyone who enters Guantanamo Bay is confined. So if you want to think about how this is resolved, proper spot testing, the spit test before anyone gets on a plane and after, a vaccine, or if, I'm surprised we haven't heard yet the suggestion that they do something sort of remotely with maybe one lawyer in the courtroom with the detainee, people wearing masks, and a judge, and everybody else participating elsewhere. I think that the lawyers would say that's not part of their fair trial rights, but how they get this going, I don't know. I think we're more likely to see a USS Cole case hearing if the judge wants to go forward on it and a different judge, because it's just a smaller number of people participating. I'm usually the only reporter there for it.
But Carol, different subject. This really is a question for both of you, from Lenora Beakey. Just briefly, if we can touch more on the torture issue. A question about, can you discuss last week's decision that torture can be considered in the sentencing of Guantanamo detainees convicted of a crime? Implications of that.
So the short of it is that in the military justice system, there's something called Article 13, which recognizes that a soldier who's been held in detention may have been held unlawfully. The classic case of this is Chelsea Manning was held under suicide watch with very harsh conditions at the Quantico Brig, and the judge in that case decided to give the soldier more than 100 days credit for that abusive treatment towards the ultimate sentence, which was 35 years. So, I mean, it's a scale thing. But the debate was whether judges at the military commissions have the right to do this. The prosecution said not. They said it's not in the law. If it's excluded, they can't have it. A judge, the chief judge, decided that absolutely he is a military judge, has that authority, and he's asserted this in a outlier case of a Al Qaeda courier who has admitted and pleaded guilty, in part because I understand because he wants to be able to explain the terrible things that happened to him in CIA custody. This is separate from a sentence. This would be, you would get your sentence and then you would get a certain amount of credit. If you spent 3.5 years in the black site, you know, the argument is you should at least get a day for day for that unlawful punishment. The judge did not decide that this man was tortured. He did not decide that he was entitled to credit. He decided only that he has authority to grant this under a procedure that's going to be worked out at sentencing. What's I think potentially consequential about this, from our conversation with David earlier, is that this may require the CIA to pony up some witnesses and pony up some evidence, that the judge may decide that he wants to hear from people who were there, to hear a different version than is maybe offered. And the CIA, you know, these cases are a balancing act of fair trial rights and national security. And as the pendulum goes back and forth, if the CIA won't give the evidence or the witnesses that a judge decides are the only things that can make this a fair trial, and the CIA says no, the trial stops. The judge abates, the judge can dismiss. And so part of this has always been sort of, in these 8 years of the 9/11 case, this struggle over how much will the CIA give and how much will the judge support this security structure. So this is a small acknowledgement that I, the judge, have the authority to explore that aspect of it. And the reason that some people in the human rights community and the anti-torture community are so excited about this is that this is so far the only judge who has said, I have the authority to look into the CIA black sites and give something that, people think compensation is money, but this is a remedy that would be time. And it would be, potentially on paper, you are entitled to X number of days to not have been detained because of what we did to you. So it can be very symbolic, and it's just, everything about Gitmo is incremental, but it's incredibly important right now.
David, thoughts on that?
No, I think that's right. I mean, the one potential relevance of torture is it infects the evidence that's used, and the government has gone through all kinds of efforts to try to not rely on that evidence because they recognize that would be a problem. But this, gets the torture sort of back front and center, because if it's relevant to punishment, if it's relevant to sentencing, then the defense has the right to present that evidence, and that's why I think as Carol mentioned earlier, many people talk about the decision to disappear people into secret prisons and to torture them as being the original sin. It is very hard to separate out what happens to the people at Guantanamo from what we did to them originally, which is why, one of the reasons, just one, why what we did to them originally was so stupid as well as so venal.
And why it's so painful and one of the reasons why this is so painful for the victims, because they just can't get where they want to go so far.
Right. Carol, we're at the end of our time, but I wanted to give you a moment to talk about your role as a journalist on this, and sort of covering this for many years, longer than anybody else, first for the Herald and now with the Times. What that shift has been like for you in terms of the way you approach the story, the resources you've had going into it, and then just reflect on the challenge of covering topics like this that are expensive, very long term, in a period when we're just seeing disappearing resources for journalist organizations all over the world.
I mean, if we're talking about the world of journalism, it's shrunk. Beats don't exist the way they used to, and I consider myself exceptionally fortunate to be able to focus on this full time. Reporters don't, and it's not a luxury, it's important, but they don't have the ability to focus on a single thing that's far away and sometimes feels irrelevant to some editors, perhaps. And some of the American people. I mean, when I was at the Miami Herald, which is rich in Cuban American population, there'd be people there saying, why aren't you covering the Cuban prisons? Why are you covering our prisons? So, the priority is a hard one, and it's an important one. And the short of it is, of course, they chose to build a court and prison out of reach of the American people. And I had a very long view, smart editor who said, we're not going to make it out of reach of American journalism, and set out a commitment that, you, John, and the Times have continued. But, the thing about covering Gitmo is there was a time when the media was welcome there, and when the story was big in front page news, and the administration was telling us we got him, and that they showed people in orange jumpsuits and said, and it made people maybe feel better that we had, captured the perpetrators, even though none of those people have ever been accused of that attack, the ones in the orange jumpsuits. But then the media wanted us there. But when then the military wanted the media there. But when the questions got harder, when the detainees obtained rights, when the enterprise became unpopular, when the American people started asking the questions, and the reporters were asking them too, and had been before, the military really, through the years, has turned on the media. This is a faraway place controlled by the Pentagon, and there are people down there who just want to be left alone to do their thing, that to be left to their own devices. You know, I have been asking questions, this is very narrow, but I have been asking questions about asymptomatic COVID down there, because to me, it's like a hugely unexplored thing. The hospital won't talk about it. The military won't talk about it. They won't talk about testing. They won't talk about cases. And somebody down there sent me a note saying, you know, if you're afraid, don't come down. Well, I'm not afraid. I signed up for the 14-day isolation. What I don't think they understand is that America chose to put that there. The Supreme Court and Congress created a court and access to lawyers, and recognized that they had access to the courts, and created a court down there. They can't be left to their own devices. You know, the judges, the lawyers haven't been there since the virus. The media hasn't been there since the virus. The military has been mostly unresponsive about the virus. There is a role for accountability, and I guess I'm sounding frustrated. So, but for every period when they shut us down and lock us out, they let us back in when there's a story that needs to be covered, or when there's a hearing that's held. And the bottom line is, I was planning to go for 14 days in a tent alone in order to cover a hearing, because I think it's that important. And I've been living off and on in a tent alone since, I guess, 2008, 7. So I've learned how to make it work. But, you know, of course I would rather be in a nice place in lockdown. But the bottom line is, they chose to put it there. I developed a level of expertise on it, and I'm just not going to walk away because they're mean.
Right. Well, thank you. Thank you, Carol, for sticking with it. Thank you, David, for all the work that ACLU has done on this. I want to thank the audience for your interest and your questions. And thanks to my colleagues at the Pulitzer Center, especially Holly Peipenberg, our producer for this session. The Pulitzer Center is reporting and education outreach on mass incarceration and related justice issues is supported by the Art for Justice Fund and other donors. The Art for Justice Fund, as some of you may know, was created by Agnes Gund in partnership with the Ford Foundation and the Rockefeller Philanthropy Advisors. I hope you all can stay with us just for a few moments longer. Remember, a brief survey will pop up once we officially end today's session. We appreciate your support by joining us with us on today's talk. And for those of you who are able to support us in other ways, just a reminder that we are a nonprofit journalism and education organization, and so we depend on donor support. Our next session, as part of the online Summer Talks at Pulitzer series with a focus on justice, is set for next week on Tuesday, June 16th. We'll have a conversation between Time for Kids executive editor Jamie Joyce, also a grantee of the Pulitzer Center, author Susan Burton of A New Way of Life, Reentry Project, and her daughter Antoinette Carter, and their focus will be incarceration and the impact on parents and children. So check over our event listings where you'll see other sessions related to justice throughout the summer, as well as webinars from students and educators, and look at sign up for our newsletter to hear about all of our reporting and events. We're doing a lot of work in the justice space, and I hope you'll follow it and work with us on these issues that are so important. So with that, thank you. Thank you again for being with us. And thank you again, David and Carol.
Thank you, John. Bye-bye.